to find ways to actually get out and talk to the students.
Is there, when a student applies and they enroll in a school and start their classes, as in everything else, you get a lot of pieces of paper. Are they provided with a piece of paper or some notification that where to go and who to contact if there's a problem, and what constitutes a problem, perhaps, if they feel that they've been unjustly served?
They are. They're supposed to be provided with a catalog and an enrollment agreement, the student performance fact sheet, and they actually receive a lot of disclosures before they sign that enrollment agreement.
And lets them know where to go if they have a problem.
Within that is the Bureau's contact information.
Very good. I'd like to follow up on the relationship of the Bureau to other regulatory entities. You've been working on those relationships, both formal and informal, with other agencies and even the DCA boards that I know you've worked with. And you're trying to get at the schools to meet the quality standards before they open and to get as much information as you can. And I know you have a broad array of tools to close bad schools, and it seems to me that you'd want to get all of the evidence possible and information possible and tools available if you ever have to do that. But I keep hearing from some that once the information is provided to the Bureau by these other agencies, nothing happens.
I've heard that as well. And the frustrating thing for, I believe, my Bureau chief and I is going back to the investigation, the laws and the regulations that govern the Bureau are separate than the laws and the regulations that govern some of our partner regulatory entities. So our investigation and following that investigation through adjudication is a different process, and the thresholds are substantially different. So essentially, are there things that we should have been more proactive about? Absolutely, and we've learned from that, and we have been much more proactive, but a formal investigation from the Bureau is completely different than a suspension of, Title IV or a different process. Ms. Wenzel, any thoughts on that?
Well, one of the things we're trying to do, and I just had this conversation with our enforcement chief within the last couple of weeks, is that what we want to go back and touch base with all of those folks that we have memorandum of understanding with and talk about what is really a violation of Bureau law so that we can basically clarify expectations. So if we have a sister agency that they have a violation of their law, it is not necessarily the same level of violation of our law. So it falls into that prioritization process, and sometimes that's very frustrating for them. But by the same token, we're, as you're all well aware, we're dealing with sometimes some much larger issues.
Yes.
So it might fall in a different place, so immediate action is not forthcoming. One of the other frustrating things that we've had is an inability to actually get access to the investigator from our sister agencies and fully utilize the investigation that they've actually done. So missing that, it forces the Bureau to go out and to try to reproduce the same investigation, and we've not had a lot of success in doing that, probably because they already know it's coming. They've already been forewarned, basically, or made aware because of the initial investigation. So without being able to use that original investigation material, that's not possible.
Is there anything that we can help with that you need from us that could improve that or clarify how we could get people to, I mean, it sounds like you're working together, but sometimes not necessarily the information is flowing the way it should.
I'm going to say I don't, off the top of my head, I don't know, but it's certainly something that we will take into consideration and get back to you.
One other issue related to other agencies is, and I've received some complaints, not regarding the Bureau, but the Massage Therapy Council of California, and there are some folks and individuals who are certified by the council, and they've attended schools that have since closed, and they may need documents in the future if they were to kind of let their license suspend and come back and have to be recertified, and how they can get that documentation so that they can be recertified. Is there can this be specified in the MOU that you're working on and hopefully continuing to work on with the council so that there is some access? I know you're the repository of a lot of those documents. I remember 10,000 boxes, I think, from a couple of years ago. 30,000, sorry, I'm a little short on that.
Those were the Corinthian boxes.
Yes.
Correct.
We can certainly address that in an MOU.
Great, that'd be wonderful, thank you. And then, let's see. No, I think I'm fine with that. So, any other questions? Yes. Assemblymember Living?
Thank you very much, Mr. Chair, and thank you both for your testimony. What's going on with the fact sheets?
The performance fact sheets?
Yeah.
I assume?
Yeah.
The regulations for performance fact sheets are in their 4th modification. And as soon as we get to the point where the comments stop on that, we'll be able to move forward with those regulations to the Office of Administrative Law.
Can you explain a little bit about the promulgation of these modifications and when the fact sheets were supposed to come out originally, and what exactly is the delay?
The fact sheet or these regulations were pursuant to 2296 block, and the Bureau, these should have been implemented a long time ago. This was one of my biggest priorities to promulgate, notwithstanding the controversy. So as my Bureau Chief indicated, 650 comments. We had to go through those comments, fold all of those comments into the process, and deal with those and bake those into the policy that we're starting to see now. Most recently, Assemblymember, the Bureau and the department made the decision to go out for an additional 15-day modification to strengthen up the regulations, to answer some of the really thoughtful questions and comments from some of the advocates. Some stuff that we thought that we can do on our own, but it would strengthen the regulations if we put them into the regulations. So 15 days, we should be back by the 3rd of April, and hopefully we'll be at Office of Administrative Law by summertime.
So this, just to clarify, this just, we didn't estimate exactly how long it would take correctly when we passed the legislation, or new things came up since 2 years ago, practically, that just made it impossible, given the resources you have, to create these fact sheets?
I would say the latter. I'm not one to constantly blame lack of resources, but it was a prioritization and something that we quickly mitigated. Once we started getting staff trained, this is a very deep, as you know, a very deep statute. So once we had staff and attorneys steeped enough to put pen to paper, that's when you started seeing the clear milestones being met with regard to these regulations. Thank you, sir.
Very good. Other questions? Seeing none, thank you, Director Kidani, and Ms. Winslow. Thank you very much for your comments, and I appreciate the progress you've made. I think we all can see that we're going in the right direction, and we look forward to the next opportunity to hear the update. So thank you. Now I'd like to invite Sean Crawford, Senior Vice President, Chief Compliance and Risk Officer for ITT Educational Services, and Robin Smith, Staff Attorney for Legal Aid Foundation of Los Angeles, for our next panel discussion this afternoon. Thank you. Please make yourself comfortable. This is a response to the California Private Post-Secondary Education Act regulations and bureau operations. We'll hear how they are doing. Mr. Crawford, would you like to go first?
Good afternoon, Mr. Chair, other chairs, and committee members. In the interest of brevity, I will keep my remarks brief and try not to repeat or be too redundant of information you've already heard. My name is Sean Crawford. I am the Senior Vice President, Chief Compliance and Risk Officer of ITT Educational Services, which is the owner and operator of the ITT Technical Institutes. Again, I appreciate the opportunity to participate in this oversight hearing on the Bureau for Private Post-Secondary Education. The ITT Technical Institutes have been operating in the state for 35 years. There are currently 14 ITT Technical Institutes approved to operate in California, and our institutions enroll more than 5,000 students. I also have the honor of serving as an institutional representative on the Bureau's Advisory Committee and was appointed to that role by the Director of the Department of Consumer Affairs on February 10th, 2010. Access to college in California remains a significant priority, particularly with providing all students in the state with an equal opportunity to succeed. As recently reported by the Public Policy Institute of California, the Campaign for College Opportunity and others, recent projections suggest that California may face a deficit of more than 1 million educated workers by 2030, which has also been referred to as the skills gap. Despite the state's commitment to higher education opportunity and economic competitiveness, the California State University, the University of California, and the California Community Colleges systems are not in a position to meet the enormous demands of high school graduates and others looking for a post-secondary education. The demand of California employers looking for these educated workers are going unmet as a result. In 2013, as previously noted, more than 300,000 Californians attended more than 1,100 private post-secondary educational institutions in California. The Bureau exercises oversight of this large number of locally and regionally focused private nonprofit and proprietary colleges and universities. These institutions are integral to the state's efforts to ensure that access to post-secondary education is and remains in reach for all California families. In my experience, the California Private Post-Secondary Education Act has been extremely effective in directing the Bureau to address significant and relevant issues, including limiting exemptions from Bureau oversight, enhancing responsiveness to student complaints, and engaging in effective rulemaking. Further, as a result of the enhancements of Senate Bill 1247 being enacted in 2014, the Bureau has worked diligently to improve the effectiveness of its enforcement process to identify unauthorized institutions. SB 1247 also instructed the Bureau to establish a task force to review appropriate standards for educational and training programs, specializing in innovative subject matters and instructing students in high-demand technology fields for which there is a demonstrated shortage of skilled workers, and these are the coding academies. I was selected to serve as a member on the task force, and in conjunction with the other members of the task force and with the support of the Bureau, believe that we have faithfully executed our charge are on schedule to deliver an approved report to the legislature by July 1, 2016. The Bureau has also been directed to adopt by regulation a substantial number of improvements to existing policies and procedures. You've heard that summary. The Bureau has been diligent in my experience in this respect, working in conjunction with all constituents to promulgate appropriate and clear regulations through the formal rulemaking process. These regulations have addressed diverse issues, including uniform reporting requirements, the administration of the Bureau, agreed upon definitions, processes for handling applications, maintaining institutional operating standards, other general provisions, and not the least, prioritization of compliance and complaint investigations and the STRIF. In my experience, the Bureau has been generally effective in conducting and managing this rulemaking process. As often repeated by Director Kidani, an integral part of the process that we work through on the advisory committee and from the institutional and consumer advocacy perspective is to ensure that we undertake a careful and thoughtful review. Bureau Chief Wenzel and BPP staff also provide regular reports and updates to the quarterly advisory committee meetings pertaining to the Bureau's strategic plan, specific regulatory initiatives, and general operations. As constituted, the Bureau exercises its oversight authority through the various divisions, which include licensing, compliance, and complaint investigation units. Again, the Bureau has maintained, in my experience, a consistent focus on efficiency and effectiveness. There's been a number of challenges the Bureau has worked to overcome, including the backlog that existed at the time when the Bureau was reestablished in 2010, the delay in approving the fiscal year 2010-2011 budget, as well as the updates we received on interim staffing and migrating staff from limited term to full-term positions. In my experience, the Bureau has been proactive in its efforts to improve these initiatives, including working to complete implementation of the recommendations presented in the March 2014 California State Auditor Report. As of our last advisory committee meeting in February, only one of 33 of these open issues remain to be fully implemented. They've also undergone a recent independent review conducted by CPS HR Consulting, which again is intended to assess existing processes and develop estimated workload and staffing recommendations. Throughout my experience, the Bureau has worked diligently to accomplish its mission, focused on consumer protection, as well as fulfilling a broad range of legal and operational objectives, all the while ensuring public comment is received and acknowledged with respect to these activities. God bless you. The Bureau has regularly reported to the Advisory Committee and other constituents on its progress with this process. These regular reports include attempts to resolve the backlog of licensing applications and student complaints, the status of STRIF claims, payouts and fund balances, and a regulatory update, which, as has been discussed, focuses on current and planned rulemaking packages. The Bureau has also worked to leverage its use of technology. We've received regular reports about the challenges they faced, and I know that the joint committees have heard that testimony today. I appreciate the opportunity to appear before you, and I particularly welcome the opportunity to share my experience as an institutional representative who has worked in conjunction with the Department of Consumer Affairs and the Bureau over the last 6 years to help provide advice and information as part of promoting an effective framework for oversight of private post-secondary educational institutions in California, with a robust commitment to ensuring effective consumer protection. That concludes my prepared remarks.
Thank you, Mr. Crawford. Other questions of Mr. Crawford at this point? Seeing none. Ms. Smith.
Sure.
Good afternoon.
Good afternoon, and thank you for this opportunity to speak to all of you. I really appreciate it. My name is Robin Smith. I am a senior attorney for the Legal Aid Foundation of Los Angeles and of counsel with the National Consumer Law Center, which operates out of Boston, although I live in Los Angeles and do that remotely. And I also served, I worked at the Attorney General's office for 9 years, where I led the investigation of the Corinthian colleges back in 2007. To start with, I want to briefly explain the larger context for today's hearing to sort of lay a little background for why the Bureau's work is so incredibly important. The Federal Higher Education Act provides for the regulation of post-secondary institutions through 3 different entities, and this is commonly referred to as the triad. The federal government, which is responsible for protecting the administrative and fiscal integrity of the federal student aid programs, accrediting agencies, which are responsible for assuring academic quality, and the states, which have the primary responsibility for overseeing schools and protecting students from illegal and deceptive practices. With respect to state oversight, an institution is eligible for federal financial aid only if it is approved by the state to provide a program of post-secondary education. The Bureau therefore serves as California's gatekeeper to billions in taxpayer federal financial aid. The need for strong state oversight of the for-profit higher education sector in particular has never been greater. Increasing numbers of state and federal investigations have revealed the widespread use of illegal practices throughout the sector, including by large accredited schools. A huge number of large institutions with thousands of students in California are the subject of recent state and federal law enforcement actions involving serious deceptive practices, including misrepresentations about graduate wages, the transferability of credits, and the employability of graduates, including the use of inflated placement rates. To name just a few, 2 of the schools that have been mentioned today, Corinthian Colleges and Maranello Schools of Beauty, have impacted thousands and thousands of California students. A number of other schools are in serious trouble, both financially and from a law enforcement perspective, all with multiple campuses in California as well as online divisions. According to a report titled Regulating Too Big to Fail Education by Chris Hicks, and this was just published on March 16, 2016, these include DeVry, Career Education Corporation, University of Phoenix, Education Management Corporation, or EDMC, and ITT Tech. Severe consequences. There are severe consequences for harmed students. The Bureau's oversight is critically important, and the stakes are high for California students, its businesses, and the economy, because education is a significant and lifetime investment, second only to home ownership in terms of financial expense and commitment. Schools that engage in illegal business practices harm the long-term economic stability of student loan borrowers, their families, and their communities. They leave students with enormous debts that they cannot repay, and students who default on their federal loans face a lifetime of wage garnishment, tax refund seizures, and Social Security offsets, including Social Security disability, without a judgment. Just a reminder, there is no statute of limitations on the collection of federal financial aid, and most student debt is not dischargeable in bankruptcy. In addition, student loan defaults damage credit ratings and impact the ability of borrowers to rent or buy homes, purchase cars, obtain affordable credit, and find employment. Ultimately, by failing large numbers of low-income students, the substandard educations and deceptive practices of some for-profit schools are a drag on the larger economy of California. I want to focus on a few key areas regarding the Bureau and the Act. As Chair Medina noted earlier, the Bureau's #1 mandate from the legislature is consumer protection. The Education Code states, in exercising its powers and performing its duties, the protection of the public shall be the Bureau's highest priority. If protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. So the primary question is whether the Bureau is adequately performing the mandate. Unfortunately, the answer is no. The Bureau should take a more proactive approach to protecting students and ensuring compliance with the law it is charged with enforcing. This isn't to minimize the incredibly huge task facing the Bureau. The Bureau probably has the toughest job in the Department of Consumer Affairs. It is charged with overseeing large numbers of incredibly complex businesses that receive billions in federal taxpayer revenues. So the Bureau's top priorities, which go hand in hand, should be to make student complaints a priority while identifying schools most at risk of harming students, using its authority to investigate and monitor those schools, and taking appropriate action when it discovers violations. I am heartened to hear that the Bureau is intending on releasing regulations or proposed regulations by June with respect to complaint procedures as well as strict procedures, and look forward to seeing those. But the need for the Bureau to focus its resources on investigating student complaints and schools that are at risk of harming students is urgent. One of the areas that I'm concerned about is the Bureau is taking 2 times longer to close investigations than it did 3 years ago. 179 average days is how long it took to close a complaint in 2012 and 2013. It is now 380 days. This is serious if the complaint concerns issues that impact lots of students, if it's a serious violation of the law. Those complaints need to be resolved quickly and investigated on a priority basis to the extent that they involve serious violations. I want to take one example just to explain, to sort of illustrate what it is I think the Bureau should be doing. And this involves Education Management Corporation, or EDMC, which operates 13 campuses in California. In 2013, the Colorado Attorney General entered a $3.3 million settlement with EDMC based on allegations that it deceived students about job prospects. In late 2015, the Department of Education and the California AG obtained a historic $99.5 million settlement based on allegations of illegal recruiting practices. And 39 states' attorneys general obtained a settlement for the forgiveness of $102 million in private loans. More students than any other school except Corinthian have submitted defense to repayment claims to the Department of Education from EDMC. EDMC is having serious financial difficulties. In 2015, Moody's Credit Rating Service dropped EDMC to its lowest rating. All EDMC schools are subject to the Department of Education heightened cash monitoring status. It has posted a letter of credit for $271 million to the department, and it is a prime example of where the department should be focusing its attention. Does the Bureau have complaints about EDMC? Has it prioritized reviewing those complaints? Do any of them involve common alleged violations? Has the Bureau reviewed or audited EDMC placement rates? Has it done undercover campus visits? There are many questions to ask the Bureau and drilling down in what is it doing as far as investigating. Is it doing undercover visits? Is it doing unannounced site visits? It doesn't necessarily have to tell you which school, but it can tell you exactly what it's doing to investigate complaints as well as to monitor risk schools like EDMC to ensure that they are still providing the educations they're promising students and not engaging in illegal practices. I'm going to move on. I'm trying to be quick. I apologize. There's a lot to cover.
Okay. Good information, thank you.
For STRIF and outreach, I did briefly want to mention, I'm really glad to hear that the Bureau wants to do more outreach to students, and I commend them on how they handled the Marinello School closure. They really did a much better job, I think, and learned from how the Corinthian closure went. They were very responsive to students, and they even handed out information about legal services for us, which meant that we saw many more students coming to us and we could assist many more. I do encourage the Bureau to start figuring out how to hold monthly workshops or to have more outreach to students that should qualify for STRIF. The STRIF application rate is extremely bad. For example, for Corinthian, it's only 300 out of 10,000 potentially eligible students have applied to STRIF. While the closed school discharge application numbers are quite high. And so that to me indicates that there is some need for STRIF outreach. I will say it isn't easy. I understand because I try to do outreach too. It's very difficult because students are not all in one location. But I think that they could partner with community colleges, with legal aids, with a lot of the nonprofit organizations that come into touch with these students in some form or other. I also would request that the Bureau post on its website information about student clinics and student legal services when available, as the Attorney General now does. I think probably most students are more likely to visit the Bureau's website than anywhere else, so that's very important. A couple last things is I just want to mention the need for legal services for these students. They face an uphill battle, not particularly with STRIF. I think the Bureau has been very good at processing applications, but with respect to other types of debt relief on both their federal and private loans. Right now at Legal Aid, we have 1.5 attorneys. I'm 0.5, and we have a young fellow 1 year out of law school. We have over 250 clients from Corinthian and Marinello combined, and we have to turn away a lot of people. It breaks my heart every time. But it's just a matter of resources. And so I appreciate Chair Medina continuing to be very interested in funding legal services. I also see it as a point of leverage. If you fund legal services for a fairly small amount of money, you can really get a lot of federal relief and federal dollars back into the state and get a fresh start for students in a way that they really can't access on their own. I finally want to end I just want to briefly discuss distance education issues. Distance education is the fastest growing segment of higher education, but out-of-state companies which lack a physical presence in California can enroll Californians in online education without complying with consumer protections for post-secondary students under California law. This giant loophole leaves Californians vulnerable to predatory marketing, low-value programs, and fraud. There is no reason to conclude that for-profit online education schools are less likely to engage in the types of deceptive practices used by brick-and-mortar schools. In fact, a U.S. Senate investigation found that exclusively online students at for-profit institutions have lower retention rates on average than students who attend classes at physical locations. And the largest distance education schools are owned and operated by the same for-profit school companies that have been the subject of multiple law enforcement investigations, including the schools I just mentioned. For example, EDMC operates its distance education programs out of the Art Institute of Pittsburgh. It has a negative 1.0 financial responsibility score for the Department of Education. It is a prime example of a school that may be going down very soon. And so it's really important to look at bringing online distance education schools, particularly for-profit schools, under the Bureau's authority. In addition, if these schools close, those students are not eligible for STRIF, and often they're not able to obtain STRIF-type relief from other states. Many of those laws specifically exclude out-of-state students from relief. So in conclusion, a strong ACT and Bureau are critical to ensuring that all students who make a significant financial investment in a post-secondary education will obtain the skills they need to improve their lives and the futures of their families. It is also critical to ensuring a skilled workforce and that schools comply with the law, do not have to compete unfairly with schools that engage in deceptive business practice to enroll more students. Thank you for considering my testimony, and I'm happy to answer questions.
Thank you, Ms. Smith. Appreciate that. Other questions from the committee? Seeing none, thank you. And I would like to ask Director Kidani again to please come up if you would, and Ms. Wenzel, if you're still there, she is. Thank you, Mr. Crawford. Appreciate the testimony and the comments. It's very helpful. Thank you for coming back. You heard the comments in the testimony, and I'm not going to ask you specifically about a particular school or some of the issues that were raised specifically. However, when you, just as we all read in the newspaper, and you're privy to information coming from around the educational community in the country, and you start hearing some of those concerns, those problems with the financial disclosures and the limitations that some of these schools are having, and what do you do? How do you prioritize that? Do you triage it in a way that then looks at those and then follows up to be proactively looking to protect the consumer, as well as the students, as well as those tax dollars that are being used, and take some action quicker, sooner rather than later to, again, protect those students?
If I could, then you could get more specific in terms of like how it functions. But what I would like and where the Bureau is, what I would like and where the Bureau is moving and what is needed in order to realize this vision is more data, you know, and what I would like for the department and the Bureau to have is the ability to look for smoke, you know, to look at data and see trends, exactly what was part of testimony today. You know, you have trends in this sector, and if that information is in data that we can glean, then we can start redirecting our valuable resources and start investigations and hopefully get to things quicker. With that, Ms. Wenzel?